Good afternoon. My name is Erwin Chemerinsky. I want to welcome you to the second day of the Hundt Family Foundation Lecture on Democracy and the Rule of Law. Yesterday, I had the opportunity to introduce Reed Hundt, who is responsible for this lecture, and I also had the chance to introduce Professor Melissa Murray. I see that some of you weren't here yesterday. I'm sure you're all familiar with Professor Murray, but it's also a great joy to welcome her back to Berkeley Law. So I'll do a more brief introduction than yesterday, but a full introduction would take more than the hour that we have. So let me just say, Professor Murray went to the University of Virginia for college and then to Yale Law School. She did a district court clerkship and then clerked on the Second Circuit for then Second Circuit Judge Sonia Sotomayor. She began her teaching career at Berkeley Law in 2006. And I said yesterday, she was a truly beloved teacher and colleague. She won the Rudder Award for Outstanding Teaching in 2014. She was the interim dean of the law school from spring of 2016 till June 30th of 2017, with the appropriate cheer that you heard in the front row. And in 2018, she joined the NYU faculty as a Stokes Professor of Law. And it is so great to have her here and to hear her again on the topic of democracy and the rule of law.
Thank you so much for having me back to Berkeley. It always feels like coming home. Also being in this room where we had so many wonderful faculty meetings, always great to be here. I want to say thank you to Dean Chemerinsky for inviting me back to Berkeley, and even all of these years after, it's been about 8 years, going out of his way to make me feel a part of the Berkeley family, so thank you. I also want to acknowledge the Hundt family and Reed and Betsy Hundt in particular for endowing this lecture on a topic of incredible urgency and importance in this moment. Their generosity is inspired, and I hope it will continue to spark important conversations here at the law school. And then finally, I just want to acknowledge Maria Echeveste, who is here and trying to be anonymous. Maria is the widow of Dean Christopher Edley, who brought me here to Berkeley back in 2006. And whose example continues to inspire me, including this work. So thank you all for being here today and for welcoming me back. The title of this talk is called Funhouse Footnote 4, which may prompt some of you to ask, what is she talking about? So footnote 4 refers to the fourth footnote of the court's 1938 opinion in Caroline Products, United States versus Caroline Products. And it is without a doubt the most famous footnote in all of constitutional law. Caroline Products was a challenge to the Filled Milk Act, a federal law that prohibited the shipment and interstate commerce of milk that had been adulterated with other products like coconut oil or condensed skimmed milk. Congress enacted the Filled Milk Act after intensive lobbying from the dairy industry, which was keen to constrain the market for cheaper adulterated milk products. After successfully lobbying for state laws that prohibited the sale of adulterated milk products in many states, Big Dairy decided to set its sights on a federal law. And that federal law was intended to further choke the supply of adulterated milk products, capturing the market for milk. And Congress, despite the nation's depression-induced economic woes, complied. It enacted the Filled Milk Act with bipartisan support. The Caroline Products Company, however, was understandably not pleased. It was one of the largest manufacturers of adulterated dairy products, and it manufactured a very popular product called Milnut, or Milnut, and it was a delicious blend of milk compounded with coconut oil for creaminess. Already reeling from the state-level laws that had artificially constrained the market for adulterated milk products, the federal law prohibiting the shipment of Milnut and interstate commerce was likely to devastate Caroline Products. And so the company decided to sue, to challenge the Filled Milk Act. And it argued that Congress lacked the authority to enact the law, and that even if Congress did have the authority to enact the Filled Milk Act under the Commerce Clause, the Fifth Amendment's Due Process Clause was an external limit on that authority, and thus the law was improperly enacted. Now, if Caroline Products had filed its lawsuit just a few years earlier, it likely would have been successful in invalidating the Field Milk Act. In the early days of Franklin Roosevelt's administration, the court was well known for its skepticism of the New Deal Congress and its efforts to regulate the American economy. But unfortunately for Carolene Products, its lawsuit was filed in 1937, the same year in which the famed switch in time that saved 9 occurred. Eager to advance his New Deal programs by bringing the recalcitrant court into line, FDR had floated a plan to pack the court with younger justices who would be more amenable to the New Deal's regulatory proclivities. The plan never really got off the ground, and it was very firmly speculated that it was unlikely that Roosevelt could get the required votes in Congress to expand the court. But still, the threat of court packing was enough to convince at least one justice, Owen Roberts, to switch his vote in NLRB versus Jones and Laughlin, a pivotal case involving a challenge to the Wagner Act and collective bargaining. In the brief period between Jones and Laughlin and the switch in time and what it considered the Carolene Products case, the court's jurisprudence had undergone a switch that mirrored the switch in time as well. The court now took a more expansive view of Congress's authority to enact legislation under the Commerce Clause, and in doing so, it dramatically increased the number of activities that were considered to be in or to affect interstate commerce. And as such, a number of laws were now upheld under the Commerce Clause, whereas before, they might have been invalidated. But the court also substantially altered its jurisprudence in the realm of substantive due process. That's the doctrine dealing with rights that are not specifically enumerated in the Constitution. The changes meant that many New Deal programs that previously would have been struck down by the court as unconstitutional were now likely to be found constitutional. And so it was with the Field Milk Act. Relying on its recent expansive understanding of the commerce power, the court determined that the Field Milk Act was well within Congress's authority to regulate interstate commerce, and it was subject only to the restrictions of the Fifth Amendment's Due Process Clause. And with regard to the Fifth Amendment's Due Process Clause, the court saw no problem. Congress, it concluded, had a rational basis to assume that the law was necessary to advance public health goals. It was ordinary economic legislation needed to advance these public health goals that the legislature had rationally relied upon. In all, it was a staggering defeat for Carolene Products. But the decision likely would have been consigned to the backwaters of the US reports were it not for its marginalia. Carolene Products might have been nominally a case about adulterated milk products and the federal government's authority to regulate the economy. But at bottom, it was also a case about the role of an unelected, unaccountable court in a constitutional democracy where the people's representative, the Congress, the president, state legislatures, and state executives routinely took action that these unelected courts would be obliged to review and sometimes strike down. Was judicial review consistent with democracy? Should unelected, unaccountable judges be in a position to invalidate actions undertaken on behalf of the people by their elected representatives? It was the central question that had undergirded the recent fight between the court and FDR. And the court's decision in Carolene Products upholding the Field Milk Act reflected the current views of the court. If Congress had a rational basis for legislating, the court would not second-guess the wisdom of the legislature. After all, if the people objected to what the legislature was doing, then they could simply use the electoral process to register their disapproval and vote the bums out. But then that raised an essential question. Was the political process the only check on the political branches? Was there no role for the court to play in limiting the work of the political branches? Although the majority in Carolene Products deferred to Congress and upheld the Field Milk Act, Justice Harlan Fiske Stone, who wrote for the majority, was not prepared to say that there was no role for the court to play in policing the elected branches going forward. Although Stone conceded that in most cases, the court owed the elected branches deference in the reasonable exercise of their constitutional authority, in the fourth footnote of the majority opinion in Carolene Products, he briefly sketched the limited circumstances where courts should not simply defer to the elected branches, circumstances where courts were in fact obliged to review the actions of the elected branches with more exacting scrutiny. So what were these circumstances that warranted more searching judicial review? Stone identified three. First, where governmental actions imposed upon the exercise of fundamental rights, including, but not limited to, those detailed in the Bill of Rights. More searching judicial review was warranted in those cases because those rights were so important that they could not be left to the vicissitudes of majoritarian politics. Relatedly, more searching judicial scrutiny was warranted in circumstances where government action impaired the political process. That was because in order for a democracy to function, for the people's will to be faithfully expressed, the people had to be able to express their preferences and their objections to their representatives at the ballot box. Accordingly, courts were obliged to intercede when the government had taken steps to render the political process less responsive to the people. Finally, Stone recognized that regardless of where the political process functioned properly, there would still be groups, what Stone termed discrete and insular minorities, who, because of their minority status, their small numbers in the populace, would never be able to rely on majoritarian processes to protect their interests. In circumstances where the elected branches had discriminated against those discrete and insular minorities, the courts were obliged to intercede to protect and vindicate minority interests. Essentially, in this footnote, Stone sketched a vision for the role of the courts in a constitutional democracy. As he explained, in most circumstances, courts should defer to the work of the people's representatives, even if they disagreed with the wisdom of those actions as a matter of policy. And the Filled Milk Act was a perfect example of this. Privately, members of the court expressed doubt about whether the act would be effective, but still they acknowledged that it was well within Congress's commerce power to enact the law, and as such, they deferred to Congress and they upheld it. But not every government action warranted such deference. When the government's actions involved fundamental rights or impaired the political process so that it was no longer a means for the people to express their will, or where it discriminated against those discrete and insular minorities who could not vindicate their interest in majoritarian politics. In those circumstances, the courts could not simply defer. In those circumstances, they were obliged to step in and to review the government's actions with more exacting scrutiny and possibly invalidate them. Now, to be sure, Footnote 4 is far more well-known than the decision in which it is nested. I doubt many lawyers could wax lyrical about the facts and resolution of a challenge to the Filled Milk Act, but almost all lawyers, and certainly all law students here at Berkeley, know Footnote 4 of Caroline Products. Because Caroline Products Footnote 4 is the settlement on which our understanding, our modern understanding of the court as a defender of rights and of minority rights in particular, has been built. Consider what followed in the wake of the court's 1954 decision in Brown versus Board of Education. There, the court famously overruled Plessy versus Ferguson and declared separate but equal and the Jim Crow regime that it underwrote to be inconsistent with the Constitution. In the immediate aftermath of Brown, the South was in open revolt. Not only did Southerners drag their feet at integration, they openly challenged the court's authority to mandate it. Alongside calls to impeach Chief Justice Earl Warren were more academic challenges to judicial review that framed the court's actions in Brown as counter-majoritarian. As these critics mused, how could a court of 9 unelected lawyers overrule the wishes of a majority of Southerners, as reflected in the policies that had been enacted by their elected representatives? As this logic went, the Brown court's overruling of Plessy was not just wrong, it was anti-democratic. Similar concerns attended the court's decisions around voting rights. In upholding the Federal Voting Rights Act of 1965, which imposed upon the state's traditional authority to administer their elections in the manner of their choosing, the court opened itself up to more claims of counter-majoritarianism and the additional claims of federal overreach. Not only did the VRA ignore the wishes of a majority of Southerners, it made the states subordinate to the federal government in the administration of state elections, an area of traditional state authority. or so the logic went. Controversy over the court's actions in Brown and in those voting rights cases roiled for decades. And then one scholar stepped into the breach to answer the question of whether the court's actions in those civil rights cases had indeed been proper and consistent with democratic ideals. In his 1981 book, Democracy and Distrust, A Theory of Judicial Review, constitutional law scholar John Hart Ely sought to defend the Warren Court and its decisions from claims of counter-majoritarianism and judicial activism. Building on footnote 4 of Caroline Products, which identified a more searching brand of judicial scrutiny for circumstances involving impositions on fundamental rights, impositions on the political process, and discrimination against discrete and insular minorities, Ely argued that the court's role was to bolster and safeguard the infrastructure, the processes of democracy in order to facilitate political participation. On this account, judicial review was entirely legitimate if it was deployed to facilitate the political process and protect the interest of discrete and insular minorities to participate in it. This is how Ely defended Brown and its overruling of Plessy. It was a necessary intervention intended to facilitate the political participation and inclusion of a previously and historically subordinated group. Likewise, the Warren Court's voting rights decisions were also patently legitimate because they helped to make the political process more representative by including in the electorate those who had been formally excluded. So again, more people more likely to reflect the will of the people. And Ely's analysis proved eminently persuasive. Although Brown and the voting rights decisions were criticized when they were announced, over time, they have come to be viewed as legitimate, even canonical. So much so that even conservatives concede that Brown and the voting rights decisions that followed were rightly decided. This is all to say that footnote 4 was and has been the foundation for the court's modern civil rights settlement. It is the bedrock on which the court's role as a defender and protector of rights, and minority rights in particular, is rooted. But if footnote 4 is the court's origin story, and the origin story of its status as the modern defender of civil rights, what explains the Roberts Court? Much ink has been spilled on the Roberts Court's approach to stare decisis and precedent, and that is hardly surprising. In just the last 5 years, the court has overruled extant precedents on issues that range from abortion to jury convictions to property rights and unions. It has also substantially narrowed and limited existing precedents relating to affirmative action and voting rights. It has curbed the reach of earlier decisions in ways that significantly disrupt and distort the jurisprudential and the electoral landscape. Given that track record, it is hardly surprising that some constitutional law scholars argue that the Roberts Court no longer reflects this vision of the judicial role that Ely outlined in Democracy and Distrust. In fact, in an article entitled The Anti-Caroline Court, Harvard law professor Nick Stephanopoulos argues that the Roberts Court has fundamentally disavowed the core tenets of Ely's vision of the court in a representative democracy. Now, Professor Stephanopoulos is surely correct in observing that the Roberts Court does not wield the judicial power in the manner of the Warren Court. But as I argue, it would be a mistake to label the Roberts Court an anti-Caroline court, because the Roberts Court is, in fact, following footnote 4. It is exercising judicial review and the authority to reconsider and even overrule past decisions in order to vindicate fundamental rights and to safeguard the political process and to protect minorities. The difference lies principally in how the Roberts Court conceives of fundamental rights, assaults on the integrity of the political process, and the identity of those minorities deemed worthy of the court's protection. Put differently, the Roberts Court is exercising its judicial power with footnote 4 firmly in mind. But it is not the footnote 4 that we have come to know over the last 5 decades. Rather, the Roberts Court is pursuing a distorted vision of footnote 4, a funhouse footnote 4. And so what do I mean by that? How many of you have gone to a carnival where there's been a funhouse with a mirror? Yes, you've been to one? Yes. Sometimes the mirror renders you larger than you are in real life. Sometimes it renders you more svelte, that is my favorite Footnote Funhouse mirror. Either way, the mirror is distortive. It distorts the image, and it often renders an inversion of the image. It is recognizable in its contours, but ultimately, at its core, it is substantively different. In the jurisprudential context, the court's distorted vision of Footnote 4 operates in much the same way the Warren Court's pursuit of Footnote 4 did. The court now understands itself to be protecting fundamental rights and preserving the political process and vindicating the rights of discrete and insular minorities. It just has a fundamentally different understanding of what that charge means. Consider the Roberts Court's treatment of fundamental rights. As I've discussed before endlessly, in 2022, the court overruled two key decisions in its abortion jurisprudence. Roe versus Wade, decided in 1973, and Planned Parenthood versus Casey, decided in 1992. And it did so on the view that the Constitution does not specifically articulate a right to abortion, and that such a right cannot be inferred from the history and traditions of this country. In doing so, the court elided a very obvious history that might have informed the question of whether the 14th Amendment underwrites a right to terminate a pregnancy. Those who drafted the 14th Amendment explicitly acknowledged that certain basic freedoms, marriage, bodily autonomy, family integrity, were fundamental human rights, and that those rights had been denied to those who had been enslaved. If liberty, as described in the 14th Amendment, was intended to be the antithesis of slavery, then the exercise of those rights were exactly what distinguish the free citizen from the enslaved. And indeed, during the congressional debates on the 14th Amendment, Senator John Sherman underscored the importance of securing as fundamental rights the rights of family and bodily integrity for newly freed African Americans. After all, he said, the trappings of freedom and citizenship would always be elusive, quote, where the wife is the property of the husband's master and may be used at his will, and where children are bred like stock for sale. On this view, Sherman surmised, quote, no act of ours can fitly enforce their freedom that does not contemplate for them the security of the home. The framers of the 14th Amendment understood rights to family privacy and bodily autonomy to be fundamental and to be implicit in the grant of liberty conferred in the 14th Amendment. But those narratives were curiously absent from Justice Alito's majority opinion in Dobbs. The Roberts Court's approach to abortion rights contrasts sharply with its approach to Second Amendment rights. As the Roberts Court made clear in cases like District of Columbia versus Heller, the mere fact that the right to keep and bear arms is explicit in the constitutional text of the Second Amendment makes clear its status as a fundamental right. And it's not just that the court regards the Second Amendment as textually conferring a fundamental right. It is that it has gone out of its way to mine the history of enslavement to expand the scope and substance of that right. The day before the court issued its blockbuster ruling in Dobbs, it issued another high-profile decision in Bruin versus New York State Rifle and Pistol Association, a challenge to New York State's concealed carry firearm permitting regime. In invalidating the New York regulatory scheme, Justice Clarence Thomas, who authored the 6-3 majority decision in Bruin, went beyond simply confirming that the Second Amendment conferred an individual right to keep and bear arms in the home for home security. It justified an expansive understanding of the Second Amendment that went beyond the home, and it did so by plumbing the history of post-bellum racial violence against newly freed African Americans. As Justice Thomas explained, during Reconstruction and Redemption, Southern states relied on restrictive gun laws and other official actions to thwart newly freed Black men who sought to exercise their Second Amendment rights. This divergent approach to 19th century history in Dobbs and Bruin is not simply divergent, it is noteworthy. In Bruin, Justice Thomas mined Reconstruction-era history to underscore the view that not only were Second Amendment rights fundamental rights that were core to citizenship, but that they should be broadly construed, not just as a matter of constitutional interpretation, but as a matter of racial justice. By contrast, in Dobbs, the court focused stubbornly on the Constitution's text and 19th century criminal laws in order to make the case that there was no constitutional right to choose an abortion. And it did so by studiously avoiding a widely available history that made clear that the 14th Amendment's grant of liberty explicitly contemplated protections for bodily autonomy and family integrity. In so doing, the court made clear that the rights it viewed as fundamental were different from those it did not view as fundamental. In doing so, it withdrew a fundamental right to abortion while endorsing a maximalist vision of gun rights. In a similar way, the Roberts Court has breathed life into a distorted vision of Footnote 4's understanding of the court as a protector and defender of the political process. Under the Warren Court, this charge had meant that the court would intervene to ensure the principle of one person, one vote. In 1962's Baker versus Carr, the court effected a sea change in politics by ruling that redistricting challenges aimed at securing equal representation could be heard in federal courts. And just 2 years later, in Reynolds versus Sims, the Warren Court articulated the one person, one vote doctrine, concluding that state legislative districts must contain roughly the same number of voters. These changes, coupled with the court's support for voting rights under the Voting Rights Act of 1965, have reshaped the electoral landscape. But in the wake of the Warren Court's interventions, voter participation by racial minorities steadily increased, and indeed, it reached an all-time high in the presidential election of 2012, where the nation returned Barack Obama, the first Black president, to the White House. And it is that history and that success that the Roberts Court has used, invoking the Warren Court's ethos of facilitating voter participation and ensuring representation of diverse voices, but with an entirely different impact. For example, in the name of protecting corporate speech, the Roberts Court, in the 2010 decision Citizens United, has defanged campaign finance restrictions and allowed corporate wealth to exercise outsized influence in the electoral process. Its 2019 decision in Rucho versus Common Cause effectively blessed partisan gerrymandering, allowing state legislatures to draw legislative districting maps in ways that consolidate partisan power and make representative government less representative to the will of the people. And perhaps most profoundly, in a series of decisions from 2013's Shelby County versus Holder to 2021's Brnovich versus DNC, the court has steadily hobbled the Voting Rights Act, allowing states and localities to enact suppressive voting laws and limiting avenues for individual voters to challenge those impositions on the franchise. The incremental hobbling of the VRA returns power to the states and to their legislatures at precisely the moment the court's gerrymandering decisions have made state legislatures less representative and less responsive to the people's will. Put simply, the Roberts Court has turned the political process logic of caroling products on its ear. It has made the political process less amenable to broad participation. It has amplified the voices of certain constituents, and it has made it easier for states to limit the impact of minority voices. But perhaps the most significant way that the Roberts Court has inverted the caroling product settlement is in its treatment of discrete and insular minorities. Footnote 4 made clear that courts should intervene and use the judicial power to protect minorities who, because of their history of political powerlessness, a history of discrimination, and their small numbers, were unable to protect themselves in majoritarian politics. On this logic, the courts were duty-bound to intercede on behalf of those minorities, invalidating laws that were enacted even with majority support. And that settlement for generations has been associated with the liberal Warren Court and its support for civil rights. But as I argue, the Roberts Court today is also acting on Footnote 4's logic. It's just that today its understanding of who is among those discrete and insular minorities is very different. Consider, for example, the court's treatment of affirmative action programs. Created in the 1950s to remedy the historic exclusion of racial minorities in government contracting, affirmative action programs soon migrated to other aspects of American life, notably higher education admissions. But over time, the court grew increasingly skeptical of the use of race in admissions decisions, but it still, in many cases, routinely upheld the limited use of race in admissions protocols. That is until the 2023 decision in Students for Fair Admissions versus Harvard. There, the Roberts Court, in a 6-3 conservative supermajority decision, overruled more than 4 decades worth of precedent, concluding that even the limited use of race to achieve classroom diversity was constitutionally suspect. In one fell swoop, the court dismantled affirmative action in higher education. But more profoundly, it made clear that it was less concerned with diversity and the inclusion of historically excluded Black and brown students, and more concerned with the deserving white students whom it believed affirmative action had harmed. In Biden versus Nebraska, also decided in 2023, the Roberts Court invalidated the Biden administration's student loan relief program. Now, Students for Fair Admissions versus Harvard and Biden versus Nebraska aren't always talked about in conjunction, but as I argue, we should understand them as bookends of the same premise. In Biden versus Nebraska and its companion case, Department of Education versus Brown, the court considered whether, in enacting the student loan relief program, the Biden Department of Education had exceeded the scope of a federal statute called the HEROES Act. However, it was clear at oral argument that some members of the court understood the key question to not be about the scope of the HEROES Act, but whether loan relief was fundamentally unfair to those who had never attended college. At oral argument in Department of Education versus Brown, Chief Justice Roberts pressed this point by invoking a hypothetical involving an imagined small business entrepreneur who had never attended college and thus would be ineligible for student debt relief. Throughout the oral argument, the Chief Justice returned to this hypothetical person who is, quote, trying to start the lawn service because he can't afford college. Justices Barrett and Alito, who joined the 6-3 majority to invalidate the student debt relief program, also referenced the imagined, quote, lawn care person who doesn't go to college and starts a lawn care business, again pressing the, quote, fairness question. Because the court dismissed Brown on jurisdictional grounds, it never had the opportunity to expressly plumb the question of whether student debt relief was inherently unfair to those who had bypassed higher education in favor of other occupational paths. Nevertheless, these exchanges at oral argument were telling. Read together, the student loan cases and SFFA versus Harvard gesture toward the Roberts Court's remedial impulses. In SFFA, the court interpreted past precedents more narrowly than previous courts had done, and instead considered both explicitly and implicitly the degree to which the challenged race-conscious admissions policies and the precedents that underwrote them injured certain constituencies. And who were those constituencies with whom the majority was principally concerned? Although SFFA versus Harvard was brought by Asian American applicants who claimed to have been discriminated against in the admissions process, the majority actually spent very little time probing the nature of these injuries to Asian American students. Instead, I'm focusing on Asian Americans' discrete claims of discrimination in those cases. The majority gestured toward the broader unfairness of race-conscious admissions policies and the prospect of qualified applicants being denied admissions in favor of obviously less qualified Black and brown applicants. Put differently, the majority's discussion literally viewed the problem in stark Black and white terms. And while the circumstances in the student loan cases had no obvious racial valence, one might argue that race and racialized grievances nonetheless shaped the court's approach to that case as well. Again, recall the Chief Justice's invocation of the lawn care entrepreneur who had foregone college. The Chief Justice did not name or otherwise identify this imagined entrepreneur, but existing labor data provides some demographic context for the hypothetical. Most small businesses in the United States are started and owned by white entrepreneurs. And if we go down even further, most lawn care businesses that are entrepreneurial are started by white entrepreneurs as well. Data can also contextualize the group that the majority perceived as the likely beneficiaries of the Biden administration student debt relief programs. More than 50% of Black students take out student loans to finance higher education, and their monthly student loan payments are the highest across all demographic groups. Indeed, as amici detailed in briefs before the court, student debt relief would immediately and significantly impact racial minorities' ability to build intergenerational wealth and capital. Viewed in tandem, the student loan cases in SFFA versus Harvard reveal the court's general antipathy for redistribution. But more importantly, these cases also make clear the court's desire to remedy the perceived injustices and injuries that redistribution may engender. Now, to be sure, redistributive policies always necessarily advantage someone over some other person. But tellingly, in Biden versus Nebraska and SFFA versus Harvard, the court's skepticism of redistribution aligns with its view that extant precedents and doctrines improperly facilitate redistribution, and in so doing, impose unfair injuries on certain groups. And critically, these new groups, these new discrete and insular minorities, are not necessarily the traditional minorities that we have come to expect. In fact, they are often the groups that we historically might regard as constituting powerful majorities. The retooling of who is and who is not a discrete and insular minority deserving of the court's protection is also visible in the Roberts Court's remaking of First Amendment doctrine. In recent years, the court has cast certain First Amendment litigants, namely religious conservatives, as besieged minorities. Now, to be sure, the national climate has concretized the view for many religious conservatives that they are indeed an aggrieved minority group. Recent developments have resulted in the increasing secularization of civil society. Now, sexual activity has become untethered from marriage rates and religiosity have declined, and the equality of racial and sexual minorities is not just a desire, it is a public policy imperative in many jurisdictions. For many religious conservatives, quote, sweeping changes in gender roles and sexual mores throughout the 20th century have sparked a sense of cultural dislocation. Indeed, the court's own rulings recognizing a right to abortion and same-sex marriage have exacerbated the view among many religious conservatives that they are, quote, being left behind in the wake of a cultural tide. And the court has embraced that framing of religious conservatives as among the discrete and insular minorities that it is obliged to protect. The court's disposition of 2022's Kennedy versus Bremerton School District is instructive. Coach Kennedy, an avowed Christian who also happened to be an assistant football coach at a public high school, repeatedly engaged in a post-game practice of praying at midfield. The school district, concerned that a school official engaged in public prayer at a school event on school property might give rise to an Establishment Clause challenge, demanded that Kennedy immediately stop his practice. Kennedy refused, prompting the school district to discipline him. Kennedy then filed suit, arguing that the school board's disciplinary action violated his First Amendment right to free exercise of religion. A 6-3 majority of the court agreed. As the majority explained, the dispute turned on whether Kennedy's prayers were private speech or government speech undertaken by a public official in the course of his official duties. The court concluded that the prayers were clearly the former. Although Kennedy was a school official and his prayers occurred on the school property, they had not occurred while he was engaged in his official duties. Apparently, he did not pray while coaching. As such, these prayers were private speech, not government speech, and it rendered the school board's efforts to reprimand Kennedy improper and unconstitutional. The school board objected that the Bremerton community was in fact a diverse and multi-faith community, and that there was deep concern that Kennedy's actions would be understood as the school district's endorsement of Christianity above other religions in violation of the Establishment Clause, the First Amendment provision that prohibits the government from endorsing or appearing to endorse any particular faith. In articulating these concerns, the school board referred explicitly to Lemon versus Kurtzman, a 1973 decision in which the court articulated the long-standing test of state endorsement of religion. In Kennedy, however, the Roberts Court waved away those concerns about endorsement or entanglement, insisting that the school district had, quote, effectively created its own vice between the Establishment Clause on the one hand and the free speech and free exercise clauses on the other, placed itself in the middle, and then chose its preferred way out of its self-imposed trap. In rejecting the school district's Establishment Clause concerns and prioritizing Kennedy's free speech and free exercise rights, the court also repudiated the Lemon Test as an abandoned doctrine. On this account, the praying coach is figured as a beleaguered victim, while the school board, with its concerns about the government endorsement of religion, is figured as an irrational antagonist scheming to use the Establishment Clause to thwart Kennedy in the exercise of his First Amendment rights. The treatment of Coach Kennedy as the victim of state over-encroachment accords with the Roberts Court's treatment of the litigants in two other First Amendment cases, Masterpiece Cake Shop and 303 Creative versus Alenis, decided in 2018 and 2023, respectively. Both Jack Phillips and Lori Smith, the respective plaintiffs in Masterpiece Cake Shop and 303 Creative, maintained that their Christian evangelical faith required them to refuse to provide services for same-sex weddings. In Masterpiece Cake Shop, the overarching clash between religious liberty and gay rights was never fully resolved because the Colorado Civil Rights Commission, the court concluded, had violated Jack Phillips's rights by exhibiting animus, that is, hostility to religion or a religious viewpoint. In 303 Creative, decided 5 years later, the court decided the question, concluding that the First Amendment prevented the state from enforcing its public accommodations law to quote unquote, compel an individual to create pure speech and communicate ideas with which the individual disagreed. The Masterpiece Cake Shop court's invocation of animus to protect Jack Smith, a straight white Christian, inverts and confounds the traditional account of discrete and insular minorities. Historically, straight white Protestants have not been viewed as a politically unpopular group or as a discrete and insular minority in need of judicial protection. Indeed, they are more likely to be understood as among the advantaged in society. Now, to be sure, demographics are shifting, and Christians now, just barely, constitute a numerical minority in the United States. Nevertheless, this shift has fueled a narrative, one that the court apparently credits, that Christians are, like racial minorities, distinctly disadvantaged, injured, and aggrieved. On this view, because civil society has become increasingly secular, Christian evangelicals have been, quote, transformed into minorities who face discrimination and subordination in public life. In this way, public accommodation laws that were promulgated to limit discrimination are now refigured as vehicles of discrimination. And Jack Phillips and Lori Smith, individuals who refuse to provide services for same-sex weddings, are transformed into victims of discrimination rather than purveyors of it. Casting Christian conservatives as minorities undermines the thrust of extant First Amendment doctrine, which emerged in the mid-20th century as a vehicle for promoting religious pluralism through protections for minority religions. As Justice Sandra Day O'Connor explained in 1991, quote, the First Amendment was enacted precisely to protect the rights of those whose religious practices are not shared by the majority and may be viewed with hostility. While it is not clear whether the Roberts Court's revamped vision of religious freedom is intended to accommodate those sects that traditionally have been viewed as minority sects, that is, quote, unpopular or emerging religious groups such as the Jehovah's Witnesses and the Amish, it is telling that in recent years, the court's free exercise clause has been deployed largely for the protection of Christian conservatives, as opposed to a wider cross-section of the faithful. And as cases like Masterpiece Cake Shop and 303 Creative make clear, the Roberts Court's muscular vision of the First Amendment threatens to effectively overrule, or at least undermine, extant precedents and legislation that prioritize civil rights ahead of religious liberty claims. In both cases, gay couples invoked Colorado's public accommodations law, These state-level civil rights laws require small business operators like Jack Phillips and Lori Smith, who are doing business in the public sphere, to serve all comers, regardless of their own religious beliefs. But on the Roberts Court's telling, it is those anti-discrimination laws that are the problem, the real source of discrimination. As the court observed in 303 Creative, laws that impose anti-discrimination mandates may compel speech, forcing the business owner to adopt and endorse a message with which she disagrees. In their zeal to protect religion, decisions like 303 Creative and Masterpiece Cake Shop turn anti-discrimination law and civil rights into antagonists. So what unites all of these cases, from gun rights and affirmative action to voting rights and student debt relief to religious freedom? When the record is arrayed before us, it becomes clear that across these different domains, religious freedom, student debt relief, gun rights, affirmative action, the court's efforts benefit particular groups. Put simply, those who have been in the majority now perversely are those who the court views as injured minorities. And their injuries are caused by society, but also by the decisions of earlier courts and earlier public policy interventions that those decisions either underwrote or facilitated. These now are the new discrete and insular minorities whom the court intervenes to protect. And so with all of this in mind, what does this understanding of the Roberts Court and its approach tell us about the court and its jurisprudence and what it is likely to do going forward? Well, certainly at one level, this account of the Roberts Court and its distorted vision of Footnote 4 provides a coherent frame through which to understand the court's approach to precedent and its dismissive posture towards stare decisis. And that perhaps can help us better anticipate what the court will do in response to certain claims. But perhaps the most important insight that we can glean from viewing the court and its work through this lens is what it means for the logic of constitutional law and equal protection specifically going forward. Under the Caroline Products framework, the Equal Protection Clause provided redress for harms against discrete and insular minorities. And for years, racial minorities, and African Americans in particular, have been understood as the exemplar of minority status due to their history of discrimination, political powerlessness, and the immutability of race. But as I argue, the Roberts Court's distorted vision of Footnote 4 upends traditional notions of minority status. In the court's imagining, there are new minorities who have been displaced by a new cultural landscape that is increasingly secularized and pluralistic. But more importantly, it is a cultural landscape that the court, through its earlier decisions on desegregation, abortion, gay rights, and civil rights, has brought into being and cultivated. And in this new cultural landscape, the laws and policies that are imposed and impose injuries on these new minorities are imposed by a new majority. And who is that new majority? Well, it is apparently comprised of women, sexual minorities, racial minorities, and other formerly subjugated groups who now, according to the court, have come together, coalesced, to collectively wield outsized cultural power and influence. This is the new woke mob. The members of this new majority, which is really the court's imagining of a glom of minorities acting in concert, is one where the court imagines them as rejecting traditional mores for themselves, but more troublingly, with an assist from earlier courts and earlier public policy interventions, have cemented the preferences of that new majority into constitutional law and public policy. And in doing so, it has allowed the old majority to be displaced, rendering now them a new minority. With that in mind, we can understand the Roberts Court's approach to Footnote 4 as not just remedial, but reparative. That is, the court's approach is aimed at making these new minorities who were once the majority whole again by restoring them to the vaunted social positions that they once occupied. But here's the rub. In order to make these new minorities who were once majorities whole, the court has withdrawn fundamental rights, invalidated student loan relief, dismantled affirmative action, undermined the Voting Rights Act, and hobbled the force of anti-discrimination law. It has effectively undermined an array of public policies that were in and of themselves remedial in nature. But in this new landscape that the Roberts Court is shaping with its decisions, those interventions are no longer understood as remedial. They are by themselves injuries. By including in the polity those who historically were disenfranchised, these redistributive measures have taken power and authority away from the majority that historically possessed it, and again has rendered that majority a minority. In this way, the court is not simply remedying harms to a new cadre of minorities. It is delegitimizing a prior round of public policies and jurisprudence that, in the name of equality, attempted to create new legal baselines and a flatter social hierarchy. In this regard, the logic of Footnote 4 goes beyond merely reshaping how the court understands itself and how we understand the court. The Roberts Court's distorted vision of Footnote 4 may, perhaps perversely, serve as the engine for dismantling an entire body of constitutional and statutory law that was, in and of itself, remedial and reparative. And it may, in the end, be the engine for privileging and prioritizing a revanchist vision of constitutional equality. Thank you. Happy to take questions. Super uplifting, I know. Professor Fletcher?
Well, that was depressing, but illuminating.
That's going to be carved on my tombstone. Depressing, but illuminating.
No, thank you for that, Reed. I feel like I just got the condensed pill of strict scrutiny from the last 2 years, like in the last 50 minutes. Thank you for that. So give us a way out of this, or what you, you've convinced me of what's up, right, on the Roberts Court, and where they're likely to head if unchecked, which, who's going to check them right now? So give us a 5, a 10, a 25-year horizon, and where do you see, like, what's going to check this? What's the end game? Yeah. What's the theory of change?
So I feel like your question goes at, it basically is the fundamental question that was posed in my tenure report here at Berkeley. I'm really good at diagnosing problems, less good at providing prescriptions, which is fair. So I think one of the things I'm trying to do in this project, which is a full-length book project, is show that these things don't happen immediately. Like, this is a sedimentary project that builds over time. It wasn't just that Coach Kennedy started praying and the court was like, that's my new minority. Like, this took some time. It was a sedimentary incremental process. And to understand that means that we might be better able to identify the beginnings of the process in other venues and other doctrines as it begins, and maybe stop it before it accelerates. It also means that we can adapt those kinds of strategies to reverse it, right? So this has been a 50-year project that culminates with the Roberts Court, but did not start with the Roberts Court. The foundation for all of this was laid with the Rehnquist Court in some respect, with members of the Berger Court, even with the Warren Court, which I maintain is not as liberal as you all think it is. It's been laid for some time. Like, there's always been this discomfort with the idea of redistribution, whether it is welfare benefits or political power. And that's part of this project. It will be another sedimentary and incremental process to unwind what has been happening. And that's a 50-year project too. And so now we sort of begin the work, if we want to, of unwinding that. Part of that begins with dealing with the political process. right? We're already seeing some of the seeds of that in certain cases. So, there was just a state Supreme Court election in Wisconsin. Who cares about Wisconsin Supreme Court elections? We should all care about what happens in Wisconsin because Wisconsin is a severely gerrymandered state. Wisconsin has 8 congressional representatives. It is a state that is basically 50-50 Republican, Democrat, but yet 6 of the 8 seats in the congressional delegation from Wisconsin go to Republicans because the state is so severely gerrymandered. And the stopgap for that gerrymandering is the Supreme Court in Wisconsin. And already they have a Democratic majority on the Supreme Court. It's 4-3. And they've begun the process of slowly unwinding some of those maps. So one of the things that they have recently done is broken the supermajority in the legislature in terms of the redistricting. So more work will be done, I think, in Wisconsin because of this recent election that will perhaps help move forward to a more representative congressional delegation, more representation in the state legislature. So some of this is about the court, some of this is about politics, some of this is about other courts. And I think one of the things we talk about in strict scrutiny is that there are lots of different balls in the air that all are important. And the difficulty, if you're trying to unwind what is happening, is that you have to be attentive to all of them. We have to be attentive to the court and what the court is doing. We have to be attentive to what is happening in Congress. We have to be attentive to what's happening in state legislatures and in state courts. And so a lot of different balls in the air, but that's the process for remediation. What's the question? Professor Echeveste.
If I were a conspiracy theorist, I would say, oh my God, they were worried about the demographic change and started 50 years ago planning for this moment. I'm not going to go that far. However, it is true that this conservative, the Federalist, this foundation is what led us to this place. My question is, and I apologize to anyone I may offend, because when I was in law school, there was no critical race theory. It was that long ago. I feel that progressives, those who put a racial lens on our country, diagnosed the problem through CRT and others, but I don't see the intellectual foundation to help us as we do the political. That's where I feel we are lacking in that foundation that can be used in subsequent legal cases at the state level, for example, where we may be more successful. But I may be wrong, because
I don't think you're wrong at all. I mean, I think critical race theory has done really important work. I think we also have to reckon with the fact that critical race theory and critical race theorists, for as long as they have been in the academy, have been delegitimized by the academy, including at this law school. Right? So these are theories and ideas that have not always been held up as valid. I can remember being a young law professor and being told, stay away from that, like it was opiates or something, don't do that. And I think you might wonder why that was, right? And you can imagine why. I mean, those were powerful ideas that could have, I think, undergirded a more practically minded kind of ethos that lent itself to litigation more forcefully. It didn't, I think in large part because a lot of it was very quickly discredited by some of the loudest voices in the academy. And I still think that we are now seeing an attack on what is known as critical race theory in K through 12 education. Spoiler alert, if your 6th grader is doing critical race theory, your 6th grader is in law school and you have bigger problems. That's not critical race theory, but the idea is to delegitimize any kind of academic pursuit that surfaces questions of race, of racial injustice, and may prompt people to reckon with the fact of a complicated past. I think in the academy, we have just written it out of hand as not the same as law and economics, for example, or not the same as other forms of quote unquote legitimate legal discourse. I think Berkeley has done an amazing job. Like while I was here at Berkeley, like critical race theory became part of what students had to learn, and I think it's probably why you now have the administration taking steps to strip that of curricula by requiring schools to do so or risk losing federal funding, because those are powerful ideas. And if they do become part of the bedrock of what legal education is, then it does have the capacity and the potential to inform what you're describing as more practically informed interventions.
We can continue the discussion.
Yes, yes. There's reception.
Please join me in thanking
Thank you.
the person for his wonderful
Thank you.